is a doctor, my lord.
ಇವಾಗೇನು ನಿಮ್ಗೇನು ಬಾರಿ ಒಳ್ಳೆ ಸ್ಥಾನಮಾನ ಕೊಡ್ತಾರ ಸೊಸೈಟಿ?
ಮಗನಿಗೋಸ್ಕರ ನಾನು ಬದುಕೋದು, ಮಗನಿಗೋಸ್ಕರ ನಾನು ಅಷ್ಟೇ
ಅರ್ಥ ಮಾಡ್ಕೊಳ್ರಿ.
My lord, now 15 years separation, my lord, now all of a sudden now unfit to have a physical relationship. He is unfit to give me pleasure.
On record.
It is on record. He had sperm problem and his sperms were low in quality and quantity, and that he both are leading separately from 2009, my lord. Your lordship had taken reconciliation. Husband and wife, my lord. Divorce was rejected in the trial court, dismissed. Lordship, along with companion Joshi, along with your lordship Justice Joshi, tried for reconciliation because almost 15 years have been separation is done. Both are living separately. So 14 years child is there. ಅದಕ್ಕೋಸ್ಕರ ವಾಲಂಟರಿಲಿ ವಾಟ್ ಯು ಪೀಪಲ್ ಕುಡ್ ಕಮ್ ಅಪ್ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ lordship had done, my lord. Then the wife, my lord, after visiting reconciliation for 2-3 times, my lord, then finally they said no, we are not ready for settlement ಅಂತ ಹೇಳಿ ಇದಾಯ್ತು ಸರ್. We had offered 30 lakh rupees. We will be for one time settlement. We will be providing 30 lakh rupees for one time settlement, my lord, to the child and the mother. 20 lakhs for the wife and 10 lakhs for the son. And we will be providing the education facility for the child and the LBT. If your honor, the wife, my lord, they did not accept ready for divorce and the LD. Idaitu son. Now we are decided both are leading separately from 2009, my lord. They say no. 2009 I had gone for the time of conceive for the delivery. I had gone. But till that, my lord, it is a matter of fact that they have not filed for restitution nor they have made any attempt for reunion. Now, my lord, since the other wife is also earning and she is a doctor, my lord, and my lord, for which we have tried for reunion, not possible. 15 years already over. Bagugegoskara we will look for till he attempt master graduation. Agoskara kudanu we are ready for providing education, my lord. Monthly pocket money goskara everything, my lord, we had. And visit ಮಾಡ್ತೀನಿ ಈ ತಿಂಗಳಿಗೆ ಈ ಡೇಟ್ ಗೆ ಫೆಸ್ಟಿವಲ್ ಟೈಮ್ ಗೆ ಎಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು we had.
You are ready to go and join?
Yes. No, not for.
Yes. You are ready to go? Yes. You are staying in Kalburgi? Yes. He is staying in Bangalore? Yes. Along with your child, you are ready to go and stay with him? Yes. What is the difficulty?
No, Lord, not for wife reunion goskara alla swami. We will.
ಅದು ಗೊತ್ತಾಯ್ತು.
Please,
you don't want her to come.
Please,
she doesn't want to give divorce.
Please,
we understood.
Please,
so therefore we are asking you, if she is ready and willing to come and join you and stay with you in Bangalore along with the child, what is your difficulty?
My lord, now 15 years separation, my lord, now all of a sudden now they say I will come. 15 ವರ್ಷದಿಂದ ದೂರ ಇದ್ದಾರೆ.
Marry another lady now.
My lord, petition was filed.
That is all right, but you don't want to take her. What is the real intention?
My lord, even from
you want to marry some other lady? Stay.
They have not filed till date, my lord, in a reunion goskara constitution ಇದು ಹಾಕೇ ಇಲ್ಲ ಸ್ವಾಮಿ. reunion restitution ಏನೋ ಹಾಕೇ ಇಲ್ಲ ಇವತ್ತು.
What are you going to achieve now?
14 years son is there. It is not in dispute that.
Yes, I remember.
14 years son is there. He was also present for yes. But as far as the second marriage is concerned, he doesn't have any.
Houdalla, we didn't ask you about that. We asked that question to him.
Yes,
not to you.
Yes.
We know that is not your intention. But what we are asking is, he doesn't want to come and stay with you, or he doesn't want to accept you as a wife. He wants to marry some other lady. What is the use of staying like this separately? You already stayed for more than how many years now?
14 years.
14 years. Court cannot force either of you. We can't force him also to accept you. We can't force you also to give a divorce to him. But you should think.
Made effort as far as that
into the future.
As far as
I remember I spoke to that
divorce is concerned, made effort, my lord. Yes, but she is not ready to accept that. Divorce is concerned. Even permanent alimony is concerned.
You have been staying separately for 14 years.
Yes,
then
since 2010.
ಏನ್ ಸಾಧಿಸ್ತೀರಾ ಅಂತ
ನಾವು ಪ್ರಯತ್ನ ಮಾಡಿದ್ವಿ ಬಟ್ ಆದ್ರೂ ಒಪ್ಪಲಿಲ್ಲ.
ಈ ವಿಷಯದಲ್ಲಂತೂ
ಪರ್ಮನೆಂಟ್ ಅಲಿಮನಿ ಸಂಬಂಧಪಟ್ಟು
even if a decree of restitution of conjugal rights is given,
that's not succeed. That will not succeed.
Ultimately, it should come from the mind and from the heart. We can't force anyone. We put that question to that lady.
Yes, Mars. Chimberly.
I remember.
Yes.
And I spoke to that boy also.
Yes.
He says he doesn't even know who this person is.
He has not made any effort to.
That is what
the evidence also.
He is not bothered.
But as far as the material on record evidence is concerned, cruelty is concerned, not a single word is there. Desertion is concerned, not a single.
ಅದೆಲ್ಲ ಆಯ್ತು.
ಎರಡೂ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ.
See, it is permissible in law for both of you to go in for divorce by mutual consent.
But that is not.
No, it is possible in law.
Yes, yes,
Isn't it?
yes.
You don't have to assign any reasons.
Not necessarily. But as far as the divorce is concerned, we have made all effort, but she is not.
ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ರಿ. ಇವಾಗ ಏನು ನಿಮ್ಗೇನು ಬಾರಿ ಒಳ್ಳೆ ಸ್ಥಾನಮಾನ ಕೊಡ್ತಾರಾ ಸೊಸೈಟಿಯಲ್ಲಿ? ಯು ಆರ್ ಸ್ಟೇಯಿಂಗ್ ಅವೇ ಫ್ರಮ್ ಯುವರ್ ಹಸ್ಬೆಂಡ್ ಫಾರ್ 14 years.
Even last year also they have.
What kind of status will you accept in the society now? Staying away from the husband for 14 years.
ಗಂಡನ ಜೊತೆಗೆ ಇರ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿದ್ರು ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಹೊರಗಡೆ ಹಾಕಿ. ಗಂಡನ ಜೊತೆಗೆ ಇರ್ಲಿಕ್ಕೆ ಬೆಂಗಳೂರಿಗೆ ಹೋದ್ರೆ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟು ಪೊಲೀಸರಿಂದ ಇದು ಕೇಸ್ ಮುಗಿವರೆಗೂ ನೀವು ಬರಂಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬರ್ಸ್ಕೊಂಡು ಹೊರಗಡೆ ಹಾಕಿದ್ದಾರೆ.
Shows that he is totally made up his mind that he doesn't want you.
Yes, that is.
I in fact told that lady, you also should be dignified in your approach. Why do you want this fellow who doesn't accept you to come and stay with you? Why should you accept him?
But the answer given by her is that on that day, ಮಗನಿಗೋಸ್ಕರ ನಾನು ಬದುಕೋದು, ಮಗನಿಗೋಸ್ಕರ ನಾನು ಅಷ್ಟೇ.
ಏನಾಗ್ತಾ ಇದೆ ಮಗನಿಗೆ? ಈಗ ತನಕ ಏನಾಗ್ತಾ ಇದ್ರಿ? ಅವನ್ ಎಲ್ಲರ ಹತ್ರ ಇರಕ್ಕಾಗತ್ತಾ? ಮತ್ತೆ at least there can be some other thing that can happen now if you make up your mind.
Yes.
We have said everything. She is actually not worried about it because she is also a doctor. She is
in the 2014 itself they have offered 50 lakhs rupees.
But you know, he is also saying I will do everything.
But sir, in the year 2014 when this same thing was happened, they have offered 50 lakhs rupees in the year 2014. Now they are offering 25 lakhs rupees.
So if it is
she is not ready at that time itself. 50 ಲಕ್ಷಕ್ಕೆ 2014 ನಂಗೆ ಡೈವರ್ಸ್ ಬೇಡ, ನನಗೆ ಗಂಡ ಬೇಕು ಅಂತ ಹೇಳಿ 14
ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಗಂಡ ಬೇಕು ಅಂತಂದ್ರೆ ಹಿಂಗೆ ಯಾರ್ ತಾನೇ ಪೋಸ್ಟ್ ಮಾಡಕ್ಕಾಗತ್ರಿ? And you are not filed any petition for restitution of conjugal rights?
No, then they are not even criminal case ಮಾಡಿರಲಿಲ್ಲ. ಈಗ ರೀಸೆಂಟ್ ಆಗಿ 125 ಹಾಕಿರೋದು ಮಗನಿಗೋಸ್ಕರ 125 ಹಾಕಿರೋದು ಹೆಂಡತಿಗಲ್ಲ. ಈಗ ರೀಸೆಂಟ್ ಆಗಿ 125 ಇಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಕೇಸು ಇಲ್ಲ, ಡಿವಿ ಇಲ್ಲ, ಯಾವುದೂ ಹಾಕಿರ್ಲಿಲ್ಲ.
Not even asking.
She is interested.
You are not asking for restitution of conjugal rights.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿದ್ರೆ ಮತ್ತಷ್ಟು
ಕೇಸ್ ಅಲ್ಲ, restitution of conjugal rights.
ಗಂಡ ಬೇಕಂತ ಹಾಕಿದ್ರೆ
ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. ಇದರಲ್ಲೇ ನನಗೆ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲಿ
ಕೇಳಿಲ್ಲ, ಸಪರೇಟ್ ಆಗಿ
ಹೇಳಿಲ್ಲ.
ಇದರಲ್ಲಿ ನಾನು
ಇವಾಗ ಓನ್ಲಿ ರಿಜೆಕ್ಷನ್ ಆಫ್ ದಿ ಪಿಟಿಷನ್ ಅಷ್ಟೇ.
ರಿಜೆಕ್ಷನ್
ಹೌದು. ಕೌಂಟರ್ ಕ್ಲೈಮ್ 23A ಕೆಳಗೆ ಹೇಳ್ಬೇಕು.
ಹಾಕಿಲ್ಲ. ಇದರಲ್ಲಿ
ಆರ್ಡರ್ ಮಾಡಿ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿ ಸಪರೇಟ್ ಅವರು ಅದಕ್ಕೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ ಟ್ರಯಲ್ ಆಗ್ಬೇಕು. ಪ್ಯಾರಾ ನಂಬರ್ 68 ಮೇಲೆ para number 68 in the bottom middle, last two lines. We have been principally influenced by the consideration that once the marriage has been broken down beyond repair, it would be unrealistic for the law not to take notice of that fact, and it would be harmful to the society and injurious in the interest of the parties, where there has been a long period of continuous
Paragraph number 16 now.
Please, ma'am. 68 minutes. 68 in para number 68. Within para number 18, there has been called on page number 5, ma'am.
Para number 68 ಇಲ್ಲಿ.
What
Extracted portion.
Please, ma'am. We have been principally impressed by the consideration that once the marriage has been broken down beyond repair, it would be unrealistic for the law not to take notice of that fact, and it would be harmful to the society and injurious to the interest of the parties. Where there has been a long period of continuous separation, it may fairly be surmised that matrimonial bond is beyond repair. The marriage becomes fiction, though supported by a legal tie. By refusing to sever the tie, the law in such cases do not serve the sanctity of marriage. On the contrary, it shows scant regard for the feeling and emotions of the parties. In view of the fact that parties have been living separately for more than 10 years, and a very large number of aforementioned criminal and civil case proceedings have been initiated by the respondent, the appellant, and some proceedings have been initiated by the appellant. Next paragraph. Reload. The said principles are directly applicable to the facts and circumstances of the case in the hand, as in the instant case also the marriage bond was broken irretrievably, and also efforts to reconcile went in vain. Matrimonial bond is broken beyond repair in the instant case also, and the marriage bond stays on trust and faith on each other. But in the instant case, that itself is lacking, as the wife is making scandalous allegations against the character of the husband and his extramarital relationship. Next relevant is last paragraph, your observation, your lordship observation. This court has also made all possible efforts for reconciliation, but they did not yield any fruitful results. The very foundation of the marriage is demolished. in the instant case due to the loss of mutual trust and faith, and as such the marriage bond is irretrievably broken as marriage bond ruptured beyond repairs. As such, no purpose will be sought by continuing the marriage bond only for the sake of records. Under this circumstance, looking to the facts and circumstances and appreciating the evidence on record, it is evident that the appellant has failed to make out any justifiable ground to interfere with the judgment and decree of the trial court. The judgment and the decree of the trial court cannot be said to be arbitrary or illegal or erroneous so as to call for Under this circumstance, the appeal is bound to fail, and accordingly we answer the point in the consideration the negative and positive following our appeals.
Let us see the facts in the case.
Please, ma'am.
Para number 3.
Please, ma'am. The factual matters leading to this case are: the petitioner husband has filed a petition under section 13(1)(I)(a) for the Hindu Marriage Act seeking divorce against the respondent wife. It is alleged that petitioner and respondent are legally wedded husband and wife, and their marriage was solemnized on 7/11/2011 at Venkateshwar Kalyana Mandapa, Gulbarga, and it was a love from arranged marriage. That after the marriage, respondent has joined the company of the petitioner, and out of the said wedlock, a son by name Aryan was born on 19/8/2012. It is alleged that after the birth of the child, relationship between the petitioner and the respondent became strained, and the respondent had refused to cook the food in the house, and also she had not cooperated with the petitioner in the marital obligation. It is further alleged that the respondent has refused to cohabit with the petitioner and did not allow the petitioner any physical contact with her without any reason, refused to share bed with him, which amounts to mental cruelty. It is also alleged that she used to insist for the payment of entire salary to her, and later on she also...
There is evidence enough to show that there was cruelty on the part of the wife. So therefore, on that ground, divorce is granted.
Now, in my case, my lord, the wife, my lord, in the entire written statement, my lord, she has degraded me on several allegations, my lord, writing, my lord, against me and my parents, my lord. He is unfit to have a physical relationship. He is unfit to give me pleasure.
On record.
It is on record. Please, my lord. Please, my lord. Objections filed by her, my lord. Okay. Para number 17, my lord, of the statement of objection. The respondent states that upon her return to the matrimonial home, the attitude of the petitioner continued in the same manner. Para 17. And there was no physical relationship between the petitioner and the respondent at all.
Previous paragraph.
Please, my lord. The respondent submitted from the date of marriage till today, the petitioner and his parents have always been ill-treating, non-trusting, and non-cooperating with the respondent on all the aspects. The respondent submitted that upon her conceiving and consummating the marriage, the petitioner started further moving away from the relationship, such as he had stopped speaking to the respondent, and whenever he returned from the office, he never gestured or equipped the respondent as to how is she feeling and what is her state of health. Whenever the respondent spoke to the petitioner, he used to walk away or abuse the respondent, and went to extent of asking the respondent to go and stay with her parents. The relationship between the petitioner and the respondent worsened, and his parents were also ill-treating and abusing the respondent. Such behavior of the petitioner caused great mental anxiety, and since she had conceived, was having nausea with fear and was totally sick. The respondent stated that the petitioner's parents requested the respondent's parent to take respondent along with them to their house for some time, but the respondent parents refused, and they requested the respondent to adjust and stay in the matrimonial house itself. But the petitioner did not want the respondent to stay in the matrimonial home, and he created a scene. Hence, the petitioner's parents again requested the respondent to go to her parents' place, for which she agreed, and accordingly the petitioner dropped the respondent to her parents' house on 19/6/2009. Thereafter, the respondent gave birth to a boy child, and on the date of the birth of the child, it was agreed between the parents and petitioner parents of the respondent that respondent and the newborn child would return to the matrimonial home after 5 months of delivery, and accordingly the respondent along with her child returned to the matrimonial home on 25/6/2010. Please, 70. The respondent states that upon her return to the matrimonial home, the attitude of the petitioner continued in the same manner, and there was no physical relationship between the petitioner and respondent at all. When all these aspects were confronted by the respondent, the petitioner abused the respondent orally. He stated that he had married to the respondent because his parents had forced him, and that he had requested the respondent to cooperate with him to conceive, as his parents wanted a heir to their family. The respondent stated that states opposed to the further studies of the respondent, and all the time the petitioner would create huge problem at the times of the respondent was preparing for her examination and would never allow her to take up her examination. The respondent states that when her parents spoke to the petitioner and his parents stated that since their son was not in a good frame of mind, they had requested the respondent parents to take the respondent with them, and thereafter they would send their son whenever he becomes normal to bring back the respondent to the matrimonial home. The respondent is still interested to matrimonial life with the petitioner. Para number 15 may be kindly perused. Para number 15. 14 also speaks about the physical relationship. 9th line. Para number 14. Para number 14 of the statement of objections.
Already ಇದರಲ್ಲಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ ನೀವು ಓದಿದ್ರಲ್ಲ,
ಅದರಲ್ಲಿ ಒಂದು ಪ್ಯಾರ ಓದ್ದೆ ಮಿಸ್. ಇದರಲ್ಲಿ ಎಂಟೈರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ objections that all that she states done physical activity
that may be contained even in the examination in chief.
Yes, madam.
Please point out.
Please. It is further submitted that the deponent realized that the petitioner had some physical and medical problem, because of which he had not bonding with the deponent emotionally or physically proper. The deponent submits that the petitioner was discussing every aspect of their and his life with his parents, and was not discussing nor confining with the deponent, and the deponent was treating as an outsider, and she had not say in his affairs. The deponent submits that when things stood that the petitioner took up an assignment in Sweden during the course of his employment, and accordingly the petitioner and deponent started living together in Sweden. Even in the Sweden, the behavior of the petitioner was hot and cold. Sometimes he was laughing around and cracking jokes, and all of a sudden he would start complaining and shouting at the deponent for silly reasons like house is a mess and it had not been kept clean, even though house was spick and span. Also used to complain regarding the deponent's cooking. Complaining and shouting started only after petitioner has a telephonic conversation with his parents. The deponent further submitted that even when they stayed together in the Sweden, the petitioner never used to confide any matters of personal or otherwise with the deponent, and she was always made to feel that she never welcomed in his life. Even when the petitioner took a decision to come back to India, he did not consult or consented the deponent, and he only stated his father was unwell. He has decided to go back. The deponent submitted that during their stay in Sweden, the petitioner did not have any proper physical relationship with the deponent. When he was confronted this aspect with the petitioner and his parent, petitioner's mother stated that the petitioner had some problem and they were all minor in nature, and deponent has to adjust and everything would be all right in a short while. The deponent further submitted that upon return from the Sweden, the petitioner had stated that he has consulted by name Dr. Shekhar Dodmani, and that he wants to undergo minor surgery, and accordingly the petitioner had undergone the said surgery, and even after the petitioner could not have proper physical relationship with the deponent. During this entire process, the deponent was having patience and tried to understand the petitioner, and in fact deponent had also tried to help the petitioner emotionally and physically. In fact, the petitioner stated that the deponent has to undergo some test to verify whether deponent had any problems. Accordingly, the deponent along with the petitioner visited one Dr. Nirmala Bhatt in Jayanagar, and during the interview with the said doctor, the petitioner spoke only about the deponent, and he did not mention his problems to the doctor, which was big shock to the deponent. The deponent submitted that the said lapse in the mentioning his problem to the doctor was because the petitioner would feel hurt and shy to state that he had some problem. The deponent did not confront him in front of the doctor, since the petitioner had a short-tempered and a revenge attitude towards the deponent. The deponent submitted that upon examination of the deponent by Dr. Nirmala Bhatt, she informed the deponent that no proper physical relationship had taken place between the petitioner and deponent. Hence, she referred the petitioner to one Dr. Watson at so and so address. Next, the Dr. Watson, upon examination of the petitioner, stated that the petitioner had sperm problem and his sperms were low in quality and quantity, and that he had to undergo certain treatment, which treatment he underwent. During this process, deponent cooperated with the petitioner entirely and actually helped the petitioner to overcome his physical and medical problem. The deponent, next paragraph. The deponent submitted the form that from the date of the marriage till today, the petitioner and his parents have always been ill-treating, not trusting, non-trusting, non-cooperating with the deponent on all aspects. The deponent further submitted that upon her conceiving and consummating the marriage, the petitioner started further moving away from the relationship, such as he had stopped speaking to the deponent, and whenever he returned from office, he never gestured or inquired the deponent as to how she is feeling and what is her state of health. Whenever the deponent spoke to the petitioner, he used to walk away or abuse the deponent and went to the extent of asking deponent to go and stay with her parents. The relationship between the petitioner and the deponent worsened, and his parents were also ill-treating and abusing the deponent. Such behavior of the petitioner caused great mental anxiety, and since she had conceived and was having nausea with the fear and was totally sick, the deponent states that the petitioner's parents requested the deponent's parents to take deponent along with them to their house for some time, but deponent's parents refused and they requested the deponent to adjust and stay in the matrimonial house itself. That same paragraph. There is statement of objections to allegation that I am a bad character, bad behavior husband from the day when you came for the alliance, para number 11, my lord, of their statement of objections. The respondent submits that when the petitioner along with his parents visited the respondent's parents' house at Bangalore in the month of December 2005 for the meeting of respondent and petitioner for the first time before marriage, the petitioner's behavior was a sort of aloofness. My lord, the meaning of this, my lord, dictionary, my lord, bad behavior of the
aloofness ಅಂತಂದ್ರೆ ಒಂಥರ
not a fit person ಅಂತ ಬರೋದು.
aloof ಅಂತಂದ್ರೆ being lonely. It doesn't want anyone around. Aloofness ಅಂತ that does not have this meaning that what you are trying to attribute. ಅದಲ್ಲ. Anyway, please read it.
A sort of aloofness. Hence, the respondent's parents and relatives were of the opinion that petitioner may not be suitable for the respondent. This is what, my lord, they say that the petitioner may not be suitable for the respondent. The respondent submits that the petitioner's parents prevailed upon the respondent parents and promised that they would allow the respondent to complete her studies after the marriage, and they would allow her to work thereafter, and that as they had liked a respondent and they were very much interested that the petitioner should marry respondent, and they also stated that the petitioner was working in very good company and earning decent salary. They had residential house of their own and they would settle the same on their two sons. They have and also further stated that they would bear all the expenses of her education. Accordingly, we have borne the expenses for the education. Other para number 13, Swami, other statement of objections. The respondent submits that the respondent realized that the petitioner had some physical and medical problem because of which he was not bonding with the respondent emotionally and physically problems. The respondent submitted petitioner was discussing this same was read in the examination.
And despite of all this, you say, no, I don't want to divorce.
As far as
ಎಲ್ಲ ಹೇಳಿ
ಅಡ್ಮಿಟ್ ಮಾಡಿದಾರೆ ಅವರು
ಎಲ್ಲ ಹೇಳಿ ಅವನ ಮೇಲೆ
ಟ್ರೀಟ್ಮೆಂಟ್ ಬಗ್ಗೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಲೋ ಸ್ಪರ್ಮ್ ಕೌಂಟ್ ಸಂಬಂಧ ಅಡ್ಮಿಟ್ಸ್
ಹೌದು
he himself admits.
No, you are saying there is something wrong in him mentally, physically.
That is treatment is given. I am always cooperated with him. I stayed along with him.
So therefore, now he himself is saying, it is not possible anta.
Like his evidence mirrors in the cross examination. Kindly, cross examination.
No, please understand. The judgment is read. Yes, that was rendered by us only.
Yes,
so we can also take into consideration the fact that the marriage has irrevocably broken.
Come to that conclusion.
You have stayed away from each other for 14 years, sir.
But there is no allegation between each other. ನಾನು ಅವ್ರ ಮೇಲೆ allegation ಅವ್ರ ಮೇಲೆ allegation ಇಲ್ಲ. ಅವ್ರು ಸಿಲ್ಲಿ
ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅಷ್ಟೇ ಬಾಯಲ್ಲಿ.
I have not lost any complaint.
Everything is put in writing here.
I have not lost any complaint.
You are saying so, but you are putting all that you wanted to say in writing. Treatment is there in the statement of objections and in your oral evidence. Deposition.
Treatment ಸಂಬಂಧಪಟ್ಟು
we can take that into consideration. Please understand. It is a case where this court can pass a decree of divorce. We have sufficient material. Even at this point of time, we are asking you
whether as far as
please tell your client that this is what the court has expressed. It is possible that the court may proceed to grant a decree of divorce. You want to say something about the permanent alimony, you please say so. That's why on the next date of hearing, you can say so. Otherwise, we'll proceed.
Before that, before that, kindly his evidence. As far as 14 years is concerned, that the court comes to conclusion on that basis, I do agree. But as far as his petition for desertion and cruelty is concerned, if he has brought on record before the trial court, single piece of evidence against me, as far as cruelty is concerned, single piece of evidence to more than 2 years desertion. Within 1 year, he has filed the petition for divorce. That goes mirrors. He himself admits in the evidence how many days I was with him as the specific date on which I have left before 2 years of mandatory period. He has filed this petition for divorce before the trial court. Within 2 years of the statutory period, he has filed that grounds he can't take. Now, the question remains, cruelty is concerned. I have not lodged any DV Act complaint. I have not lodged any criminal case. I have not made any serious allegation that nature that will lead to filing of this divorce petition. In the contrary, he himself admits whatever the facts I have brought on record in my statement of objection as well as in my affidavit to the effect about his medical condition. Even though emotionally, physical, during that treatment period, I am along with him. Only when I came to Gulbarga for the delivery purpose. Again, I had been to Bangalore, stayed there at 1/7/2010 is the cradle ceremony. That is the after that 4 or 5 months I remained there in the year 2010. 1/10/2011 is the date of filing of their petition for divorce.
When you were still there in Bangalore,
Is absolutely out of record. Is submitting, my lord.
In his own evidence, not my evidence. Kindly, 4 line is there. Kindly, his own evidence.
I need to come away from there afterwards.
What was date of birth of the child is on 23/2/2010. It is not in dispute, my lord. After that, his own evidence. It is true. The naming ceremony of the child was held in my house in the month of July 2010. It is his own admission given before the trial court.
Yes.
This in the month of July 2010. They have filed the divorce petition 1/10/2011 itself. Naming ceremony was on July 2010. After that, my contention is that for a period of 5 months, I remained there. They have stated for a period of only 1 month. Assuming for the sake of argument, only 1 month. July 2010, August 2010. 1/10/2011 is the date of filing of the petition. Desertion ground goes, my lords. Against cruelty, what I have done, whether I have impeded all the family members in a criminal case to face, whether I have earlier filed any 125 petition, whether DV petition, voluntarily I had been to 10 times before their home. They have closed their door, thrown out of the house. Along with their parents, they had been tried. By the well-wishers of both the parties, they have made all the efforts. Since the proceedings were pending, police have also directed the petitioners and parents till disposal of this petition to don't go to their house. They have taken undertaking by the police. That is the reason till disposal, I have not filed any restriction. That is, I have submitted thoroughly. As far as the grounds made out by them, do not make out the ingredients of section 13(1)(a) or 1(b). Cruelty as well as a desertion. Hence, I pray the honorable court to kindly, as far as the grounds made out by them before the trial court, do not attract the ingredients of section 13 of the Hindu Marriage Act. I pray the honorable court to dismiss their petition. Till today, the respondent along with her son ready to go and join the company of the husband.
My lord, the latest apex court, my lord. Page number 67 of the booklet, my lord.
67 now?
It's page number 67 of the booklet, that citation that I provided, my lord, the apex court, my lord. What it says. Only if the wife doesn't file a restitution, my lord. Page 67 is the judgment, my lord. 2022. Volume 5, SCC 459. Para number 10, page 71, my lord. Relevant. Para 10, my lord. The perusal of the respondent's evidence does not disclose any effort made by her to resume the matrimonial relationship. She has not filed a petition for restitution of conjugal rights. Only based on this, my lord, the apex court grants a degree of divorce, my lord. And what my learned friend says is totally contrary, my lord, to it, sir. In the cross-examination, she has admitted, my lord. They came to my house only for the purpose of filing one 125 case, my lord. That too in 2022, they wanted one NCR maybe to be made. On the case Simi Sakakoskara, they have made attempt now. Apex court, my lord. In the same judgment, also the court observes, coming for 1 or 2 days or for 10 days, 30 days, my lord, will not serve the purpose to, if he has to come, my lord, after going away from the house, only coming for 1 or 2 days or for a small span of time, will not serve as if she's coming, starting a matrimonial life ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. ಅದರಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 11 ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ ಒಂದ್ಸಲ ಬಂದು ಹೋಗಿರೋದಾಗಲ್ಲ ಅಂತ ಹೇಳಿ. Yes, my lord. My lord, my client, my lord, on the instructions, my lord, even if this honorable court, my lord, 20 lakhs and 10 lakh rupees maybe as an rupees, I want to use 3 months, 4 months time.
You stayed there for 1 month.
Yes.
Then what happened?
Then meantime they have filed the divorce. After that, what are the parents in the class in the evidence itself,
Her cross should peruse it will. What is it? ಮಗುವಿನ ನಾಮಕರಣ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಮ್ಮ ತಂದೆ ತಾಯಿ
report going there. In the statement of objections itself, in paragraph number 17, it is stated. Yes, what happened after that?
Yes.
Paragraph number 17. It was the last date, my lord. She did not return, my lord. That was the date.
What she has stated, please read that. Please.
The respondent stated that upon her return to the matrimonial home, the attitude of the petitioner continued in the same manner, and there was no physical relationship between the petitioner and respondent at all. When all these aspects were confronted by the respondent, the petitioner abused the respondent orally. He stated that he had married the respondent because his parents had forced it, and that he had requested the respondent to cooperate with him to conceive as his parents wanted a heir to the family. The respondent states that the petitioner opposed to the further studies of the respondent, and all the time the petitioner would create a huge problem at the times the respondent was preparing.
So she has not stated anything as to what happened after that. When did you leave? Legally examination ಇದೆಯಾ?
Yes.
Yes. Para number 17 of the chief affidavit.
In the statement of objections and in the examination in chief, you have not stated what happened after that. When did you leave, or when you whether you were thrown out? Nothing you have stated. ಹೇಳಿ ಪೆಟಿಷನ್ ಅಲ್ಲಿ
in the year 2.
ನೀವ್ ಯಾರು ಹೇಳಿದಿರಾ?
Petition, she was not allowing the petitioner to see the child, but still petitioner waited with a great hope that the respondent will change her attitude, but the respondent continued the same by creating untold mental trauma and agony to the petitioner. But I waited with a great hope that after some time the respondent will mend her behavior and she will join with the petitioner. It is further submitted after 6 months the respondent changed her residence and did not give information regarding her new residence. When the petitioner tried to contact her through phone, the respondent did not respond, and the petitioner even to this day respondent did not disclose her new residential address. The petitioner submitted that he being hailed from the respondent. Listen. Another fact, my lord, this responding, my lord, all of a sudden when she went, my lord, they changed and I issued legal notice to their 5 of their addresses, my lord. They changed their mobile number, mane vasa kuda change ಮಾಡ್ಬಿಡ್ತಾರೆ, exhibits mark ಆಗಿದೆ, exhibits. They will change entire address, my lord. My lord, with regard to one, only if they say ನಾನು ಇವತ್ತಿಗೂ ವಾಸ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದೆ, that cannot be considered and looked into ಅಂತ ಹೇಳ್ಬಿಟ್ಟು our division bench high court, my lord, page number 36, my lord, page number 36 of the booklet, my lord. Adil para number 20, your honor. Page 41, page 20, para 20, page 40. The contention of the wife that she is even now ready to live with the husband, if examined in the light of the allegation of both husband and wife, appears to be mere statement without there being any substance. When the allegations of the taken note of living together by husband and wife is out of question, where of the offense?
41.
The husband, if examined in light of the allegations of both husband and wife, appears to be mere statement. File and single affidavit about line.
But the learned counsels on both the sides. Stop. Learned counsel for the appellant submits that this court, in the after hearing the parties in camera, had made certain suggestions and had requested the learned counsels on both the sides to prepare a joint compromise petition showing that the responsibility that the appellant would take insofar as the child is concerned. Stop. The appellant was also required to make a statement as to the permanent alimony he is prepared to pay to the respondent. Stop. However, since the respondent has backed out, the learned counsel submits that he may be permitted to put the same in the form of an affidavit. Stop. Next paragraph. Permission is granted